Audio check. Hey, welcome back, everyone. Just before we go back to examination in chief, Mr. Young just wanted a word on conditions.
We've had a few queries about how we intend to run the conditions session tomorrow. We are still intending to do it tomorrow along with section 106, but clearly we are going to be still dealing with this witness tomorrow, so I think in the best case scenario it won't be before the mid-morning break, and we may not even get to it in the morning. So we can't say with any certainty at what point that's going to start tomorrow, but we still intend to do it rather than it running over into next week. So what we'll do is it will be conditions first, and then it will be the section 106. It will be a round table discussion. If we do have anybody here from the Highways Agency, we'll probably deal with that matter first, and then we'll move on to the other conditions where there's still disagreement. I don't think there's anything more I can say, but of course, you know, we'll update everybody on timings as we sort of go through this afternoon and into tomorrow morning.
Okay, if there's no comments on that, Mr. Humphreys.
Mr. Melling, we've touched then on some national policy issues, and I'm keen as soon as reasonably possible to get on to your planning balance, but I just want, in order to set some context for that, to just go through elements of your proof just to see what leads up to section 8, which is the planning balance, and then we'll deal with that. So in your proof of evidence, could you turn first to page 20, which is the need for the proposals?
Yes, I'm there.
And we can see there, looking at the structure of this document, that this is dealing with need of the appeal proposal and benefits. And section 3.2 deals with UK economic policy objectives and levelling up. And then section 3.3 deals with national aviation policy, of which making best use of runways is obviously part.
Yes, that's correct.
And then on page 31, meeting passenger demand, and you set out there and summarize the evidence in relation to that. And section 3.5 is then benefits. So just dealing first with the overall national economic objectives, levelling up, and aviation policy, including obviously making best use, and then the demand figures in section 3.4. How do those elements of both policy and demand translate into a demand that should be met, a need?
Yes, I think I set out that making best use is quite clear. The government expects airports to make best use of their capacity. The forecasts have demonstrated that there is demand for passengers to reach 12 million per annum under the core case in 2030, and that has been agreed between Mr. Brass and Mr. Foley. And my argument is that that is a demand that needs to be met. That is what policy, the National Aviation Policy requires.
And how does that feed into economic objectives and levelling up as well?
So yeah, what I think, as what I said earlier in my evidence, was that the policy objective of making best use and support more generally for aviation really underpins the government's wider economic priorities and objectives, including levelling up.
And then 3.5, you deal with, this is page 40, benefits, and you look at the three pillars here of economic benefits and then social benefits, and you identify what those are, including benefits because of proximity to two of the Southwest's most deprived areas, and then environmental benefits, and you identify a whole series of those. And then you come to section 4 in the evidence. And section 4, starting on page 49, has 5 main subparts, and they all have a similar structure, so we probably don't need to look at absolutely all of them. But if we take surface access as 4.2, the first one, we can see you consider, you set out a summary of the assessment, you set out and review the NSC and third-party comments, and then, and we see it in this example for surface access, page 55, a detailed policy compliance section that deals with all of those relevant policies, and you come to your overall conclusion on page 58 for that topic, where you conclude that the appeal proposal is in accordance with, and then you set out the relevant national and local policies, and then you do that for the other topics in section 4.
Yeah, I've adopted the same that approach. So I consider in the reasons for refusal. I then take the reader through what the assessment, what the evidence is telling us, before considering the comments from NSC and other parties, and then finally I come to my conclusion in terms of compliance with relevant policy.
And does that ultimately feed into your section 38.6 planning balance assessment at the end, which we will come to?
Yes, yeah, once we reach, I think it's section 8 of my proof of evidence, yeah, you'll see how all that kind of, I bring all that together.
And then section 5 is Greenbelt. We obviously dealt with that in your case earlier in the week. We don't need to re-go over that ground. Section 6, which is on page 126, you deal with a discrete number of issues raised by third parties on a thematic basis. Your table 6.1 identifies the 4 issues and which party has raised those.
Yes, just for the benefit of the inspector, so they're generally issues that that don't appear in the reasons for refusal, but have been raised as issues by other parties. So I felt it right to address those there, and I do the same in my rebuttal as well.
And then section 7 on page 137 is a short section on conditions and obligations, and obviously we'll have a session on that tomorrow, and we know that that's a relatively fast-moving section.
Things have certainly moved on since then.
And then we come to planning balance, and that's what I'd quite like to get you now to comment on, and you start that whole section by founding it in the legal duty in section 38.72 and 38.6, and you structure this section around the reasons for refusal, and we'll go through each of those, and then you consider you come to conclusions on that, and then having looked at the section 38.6, compliance with policy issues by reference to the reasons for refusal, you'll come on and we'll touch on this. You look at the other material considerations which go into the planning balance, and then there's a conclusion at the end, the overall where the balance lies. So
That's correct.
just returning to section 8.2 and reason for refusal 1, this relates amongst other things to socioeconomic benefits. Just very briefly explain to the inspectors what the conclusions were you came to and how you came to them.
Yeah, certainly. So my conclusions, again, I've pulled together the more sort of detailed analysis that's in the preceding chapters of preceding sections of my proof of evidence. But yeah, in summary, in the interest of brevity, so I conclude based on the evidence that the socioeconomic benefits of increasing the capacity of the airport will be significant. Those benefits include the creation of thousands of job opportunities and the potential inbound tourism impacts as well. Obviously, reason for refusal 1 is about balance in itself, actually. So based on the evidence and the analysis I've undertaken in the previous sections, and taking into account the mitigation measures proposed by BAL, by the airport, I conclude that the environmental impacts will be modest, and that they have been satisfactorily resolved in accordance with policy CS3. And in that, I've also considered the environmental benefits, which I set out in the needs section of my evidence. And I note that is the same conclusion that was reached by officers in recommending approval of the planning application. And that ultimately leads me to the conclusion that the development is in accordance with policy CS3. And on that basis, I reject reason 1.
And you say CS3, I think it's CS23.
Sorry, 23, yes.
23, sorry. Fine, and again, we can see the more detailed working in section 4, where you go through various...
Yes, a lot more detail.
A lot more detail. Yeah. Reason 2, this is the one that relates to noise and impact on air quality would have a significant impact on health and well-being of residents, and the proposed development would not contribute to improving health and well-being of the local population, contrary to a number of policies. And again, in the context of section 38.6, what are your conclusions on this?
Yeah, so my headline conclusion is that the air quality, noise, and adverse health impacts won't be significant. And just to unpack that slightly. So, in terms of air quality, I note that the concentrations of pollutants will remain within the relevant legal limits, and will ensure that relevant limit values continue to be complied with. In terms of noise, I do note that there will be an increase in nighttime noise levels and above the SOL, but that the changes in noise levels will be small and not significant. So that takes into account the evidence presented by Mr. Williams. I also note as well that Mr. Williams and the assessment that's contained in the environmental assessment addendum identifies that for some receptors there will actually be noise benefits. And I set out again, I won't go into the detail, but it's there in the preceding sections of my proof of evidence. I then also take into account the mitigation measures proposed by the airport in respect of air quality and noise, and I note that that includes an enhanced noise insulation scheme that goes beyond the requirements of national aviation policy and indeed the recommendations contained in Aviation 2050. I also consider the conclusions of the health impact assessment that's presented in the environmental statement and that's subsequently updated in the addendum to that document alongside the evidence of Mr. Piper, which we've heard, which identifies that there will be significant health benefits. So I take that into account there.
And in relation to policy CS3, where effects have to be mitigated to an acceptable level, you heard me raise the point with Mr. Gertler, whether you took into account the characteristics or benefits of the development in that. So taking, for example, air noise, you made the point just now that there are actually some residents who get an improvement in air noise over time, and some who will newly receive noise insulation.
I think it's only proper that you obviously take those elements into account when coming to a conclusion on whether an impact is acceptable or not.
Thank you. And then you set out there your conclusion on policy compliant. Reason 3, this is the one about carbon emissions, and the reason for refusal is that we would not reduce carbon emissions and would contribute to not contribute to a low carbon future, and would exacerbate climate change. Again, your conclusion is we know what the agreed test is, as set out, as we discussed before, in the AMPS at paragraph 5.82. How does the proposed development perform in relation to policy for that reason for refusal?
Yes, so in terms of that, well, first of all, I consider that there isn't a policy requirement that emissions from development have to be reduced. There has to be anything like that. I applied the test that was agreed in, that we talked about earlier, and I conclude that the increase in the capacity of the airport won't materially affect the ability of the government to meet its climate change commitments, and that reflects the evidence that is presented in the environmental statement addendum and the evidence that was provided by Dr. Osand-Ireland as well. And do you want me to go further on that point? Just to unpack that very, very slightly. That in coming to that conclusion, like Mr. Osand-Ireland, Dr. Osand-Ireland, I've taken into account the scale of emissions that would arise from the development, taking into account as well that in the context of the sixth carbon budget now, and also the government's policy commitments and its legal requirements to meet its budgets and targets. and also the various levers or mechanisms that the government has available to it to meet its obligations.
And as far as policy CS1 in its first criterion says that development should demonstrate a commitment to reducing carbon emissions, if we just consider for a moment the carbon emissions that are under the control of the
Yes, yeah.
airport, it's scope 1 and scope 2 carbon emissions, and the draft CCCAP that will become obviously the subject matter of a condition. Has the proposed development demonstrated a commitment to
Yes,
reduction?
there's a difference here, isn't there, between a commitment to reducing emissions and there being an overall reduction compared to the baseline. But yes, I take into account in particular, two things actually. The very strong commitments that Bristol Airport have demonstrated to date. So outside of this application, in setting targets to reduce its emissions. Indeed, I think the Bristol Airport is actually referred to in the decarbonisation plan as being a sort of exemplar airport in that regard. But then I also focus on the carbon and climate change action plan that the airport would bring forward, and I think indeed has submitted a draft action plan, which the inspectors will be aware of, which sets some very clear commitments there in terms of carbon neutrality and net zero.
And reason 4 is the one about the silver zone car park and the green belt. I'm happy to take that one as read. You obviously did deal with that before, but does it ultimately feed into your overall planning balance?
Yes, it does, and I won't bore everyone with going through that again, but I conclude in short that the development will result in only limited harm to the green belt, and that in any case there are very, very special circumstances which we've discussed at length, which outweigh that harm.
And then the final reason is that the proposed public transport provision is inadequate and will not sufficiently reduce reliance on the car to access the airport, resulting in an unsustainable development contrary to the MPPF and again some policies. And again, there was in section 4 of your proof a very substantial testing of the evidence against a policy, but just the sort of the summary of the summary here.
Yes. So I start off, I consider actually two things here, so not just sustainable travel, but also impacts on the highway network as well, and highway safety. And I take into account the findings of the transport assessment addendum, which demonstrates that even on a reasonable worst case basis, the development won't prejudice highway safety and or result in severe impacts in terms of traffic congestion, and that obviously takes into account the proposed mitigation measures that would form part of the Section 106 or whatever form that takes, including as well the A38 works.
And then,
sorry, I was just going to just to expand on that way in terms of sustainable travel as well. I take into account the stretching and ambitious public transport mode share target that is proposed by the airport.
and then you refer to the additional matters which you've taken into account in in this section and whether they are proper reasons for refusal, ecology, residential amenity, water quality, vibration, land quality and historic environment, and landscape and visual impact. And you say they don't amount to basis to dismiss the appeal. You then come to an overall conclusion, and then you, as part of the overall planning balance, look at the other material considerations. You look again at national planning policy and the economic, social, and environmental objectives of that. Again, aviation policy, including obviously the APF and MBU, and over the page, the need for and benefits of the proposals. And then you get to section, the section at 8314, you there take into account other considerations such as the government's net zero target, and then you come to an overall conclusion, and we can see that your overall judgment is that the need for and significant benefits of the proposals outweigh the limited adverse impacts associated with increasing capacity, and you invite the inspectors to allow the appeal. Is that
Yes,
right?
that's correct, and I review that conclusion as well in my rebuttal and come to the same position.
Mr. Melling, thank you very much. Thank you, madam.
Thank you. Speak into the microphone. I've got a quick question just for
Yes,
you now.
certainly.
If you can turn up page 135 of your proof. It's the other planning matters section.
Just bear with me. Yes.
Yeah. It's paragraph 6.6.8, historic environment. And there's been identified potential to affect a scheduled monument. And talks about the landscape bund as mitigation in the Silver Zone car park. And we obviously heard about the bund in terms of greenbelt
Yes.
effects.
Yeah, that's correct.
Just how do they work together? So we've got this bund mitigation for historic environment, the scheduled monument, but sort of greenbelt. Just interested to hear your thoughts on that.
Well, yeah, I mean, the bund is providing a number of purposes. One is landscape and visual, so providing that screening. And second, there's some ecological benefits as well, some ecological mitigation with that. And third, yes, it performs there's a screening benefit in terms of that impact on the scheduled monument. And I think that confirmed that there wouldn't be any significant effects on that monument, taking into account the screening, and that was the same conclusion that was reached by officers, and I think actually Historic England came to the same conclusion as well.
Okay. All right, thank you. Thank you. Mr. Taylor.
Thank you. Mr. Melling, good afternoon.
Good afternoon.
I'm not going to seek to change your view on the planning balance, because that would be a waste of all our time. What I'm intending to do is to explore matters of approach and matters of weight.
Yes, of course.
But I'm not going to take every point because I would need much longer than I've estimated to do that. I'm also going to give you 2 chances to answer a question. So I will only be putting a question twice, and after that, if I don't get an answer, I'll be moving on, and I'll be making submissions as to why I haven't got an answer.
Okay.
Okay? So I want to start with climate change, please. The context for considering the implications of the appeal scheme on climate change are the duties in Section 1 and Section 4 of the Climate Change Act 2008 on the Secretary of State to ensure attainment of the net zero target for 2050 and the 6 carbon budget targets. That's right, isn't it?
Yes, that's correct, yeah.
And the inspectors are in the shoes of the Secretary of State in this appeal, and so they have to ensure that a grant of planning permission is consistent with those duties.
I don't think that's correct. I think the inspectors have a very defined role in terms of decisions on planning applications. It's for the Secretary of State to consider matters relating to climate change.
So
What's important? Sorry to interrupt. What's important here is the test. We do have to consider whether this development would have a material impact on the ability of the government to meet its climate change obligations.
yeah. So we can note then, can't we, that your evidence is based upon the premise that the Section 1 and Section 4 duties in the Climate Change Act do not bind or apply to the inspectors.
I think it's the test. I think it's the test that we've all parties have agreed. I think obviously the Secretary of State has many functions. The Planning Inspectorate, I won't speak for the Planning Inspectorate, but my understanding is they have their remit is town and country planning decisions.
Right, I'm going to try second time. Your evidence is based upon an approach that the Section 1 and Section 4 duties in the 2008 Act do not apply to the inspectors, that they don't have to have regard to those duties in taking their decision. That's the approach you've adopted.
Yes.
Right. If that approach is incorrect, and those duties do apply, it would be unlawful to grant planning permission if to do so would result in a breach of the statutory duty to ensure attainment of the climate change targets, if they do apply.
If the emissions arising from this development were so significant that they would materially affect the ability of the government to meet its targets, and that was the conclusion, and that would need to be considered in the planning balance, yes.
Right. I'll put the question again, second time. It would be unlawful, on the premise I put to you that these duties apply, it would be unlawful to grant planning permission if to do so would result in a breach of the statutory duties to ensure attainment of the climate change targets.
If that was your hypothesis, then yes, it would be
okay.
lawful.
And again, on that same hypothesis, if there is any doubt whether granting planning permission would compromise the ability to attain net zero or the 6 carbon budget targets, then the inspectors would not be able to form a rational view that granting planning permission would ensure attainment of those targets, and they would have to refuse. That's right too, isn't it?
If there was doubt, yes, my opinion is that there isn't any doubt.
Right.
I'm sure we'll come to that.
We'll come on to that, don't worry. Now, in terms of the policy test, as it were, given the statutory background and the duty to ensure attainment of targets, to be consistent with that background, it has to be demonstrated that the project will not have a material impact on the government's ability to meet its carbon reduction targets. That's right, isn't it?
That's the test, isn't it, that I think we've all agreed is the test, as is set out in Mr. Gertler's evidence, and I think he's referring to the test that's contained in the ANPS.
Let's, I just want to see how this plays out in reality for inspectors. And we've got in the inquiry CD 9.108, which is the inspector's report on the A38 Derbyshire Junctions DCO. And I just
apologies, could you just give me the reference again?
Sure, it's CD 9.108. and this is the examining authority's report and their recommendation to the Secretary of State from the 8th of October 2020 in relation to the Derbyshire Junction scheme. And as always with DCO reports, it's extremely long, but I want to take you, please, in this to page 246.
Yes, I'm there.
Yeah, and on this page we've got the heading Net Zero Carbon by 2050. And we can see that the panel says that we questioned whether the applicant's approach to carbon emissions adequately considered the government's updated target for net zero carbon by 2050 and what account had been taken of the fact that the associated carbon budgets for 2023 had not yet been published. That's referring to the sixth carbon budget, which hadn't been published. We then get the reply from the applicant, which is Highways England, and we can see in the response that at 4:15:46 that they argued, fourth bullet point, that the scheme's proportion of total UK carbon emissions is negligible, and so it can be considered immaterial. You see that?
Yes.
And if we go on to 4:15, we can see that.
Sorry, which paragraph?
Sorry, 4:15:47.
47.
The panel says, responding to our request for evidence of the impacts of the assessment of RIS2, that's the road investment programme, that they were relying on, because they said earlier that they relied upon the assessment that had been done in respect of that programme. The applicant said that it considered the confirmation in Hansard from the Under-Secretary of the State for Transport was sufficient, and that it didn't have the detailed internal assessment undertaken by the DFT available to it, because it's a separate body from the DFT, but they're within the Secretary of State's department, so it will be available to the Secretary of State when considering the panel's recommendation. You see that?
Yes.
If we jump forward in this document to page 258, we see a conclusion at 4:15:110. We consider that not enough robust evidence was presented to the examination for us to reach a view as to whether the proposed development, or the RIS1 or RIS2 programmes of which it's a part, would be consistent with the Paris Agreement. In these circumstances, we're unable to conclude whether the proposed development would cause the UK to be in breach of its international obligations. The Secretary of State will need to satisfy themselves on this matter before making their decision. So we can see there that notwithstanding the argument that it's very small, these inspectors considered that because they didn't have enough robust evidence to reach a view on whether it was consistent with climate change targets, they said, well, the Secretary of State will have to determine that for themselves. They passed it to the decision maker, didn't they? Yeah?
Yes, I
That's
see
what
that.
they did.
Yes.
And so we can see from that they were unable to conclude that the scheme would not cause the UK to be in breach of climate change targets.
In this case.
Yeah. And if we jump forward to page 260, paragraph 4:15:118, that the Secretary of State, they say, will need to satisfy themselves regarding the cumulative effect of carbon emissions from the proposed development with those from other developments on a consistent geographical scale, for example by assessing the cumulative RIS1 or RIS2 programmes against the carbon budget. So what they're saying is that as part of their decision-making process on carbon, they were unable to assess on the basis of the evidence they've got the consistency of granting consent for that scheme in the cumulative context of other growth in respect of roads against the carbon budget. That's what they're saying, isn't it?
That's what they're saying there.
Yeah. And so we can see from that that they considered that consideration to be relevant to the decision-making process, but they pass it to the Secretary of State, don't they?
Yes.
Yeah. And so if we just take that decision-making process and see if we can find any parallels with the present case, we know that MBU, the carbon assessment contained in that, is not an assessment against the net zero 2050 target or the 6 carbon budget targets. We've heard evidence on that already, that's right, isn't it?
Pardon, could you repeat that, sorry?
We know that the carbon assessment in MBU is not an assessment against the net zero 2050 target or the 6 carbon budget target.
They weren't published at that time.
And Dr. Osendialand agreed in cross-examination to me that government has not prepared any equivalent assessment to that carried out in MBU, which demonstrates that further airport expansion is consistent with the attainment of the 6th carbon budget or net zero 2050, didn't he?
From my memory, I don't think that's a completely fair reflection. I think Dr.
Right.
Osendialand referred to the assessment that is contained in Jet Zero and the associated evidence and analysis document, including the DFT revised forecasts.
Right. So what you're saying is that the concluded cumulative assessment for the aviation sector is in a consultation draft. Is that what you're saying?
That's not what I'm saying.
No.
I'm saying that's my what I recall from the evidence that Dr. Osendialand
There
gave.
is no cumulative assessment of the impact of aviation growth on a basis consistent with the 6 carbon budget or net zero 2050 before this inquiry, is there?
I have to disagree with that assertion. I think there's a couple of points. I think the first is that the government, in setting its targets, obviously has to have consideration of the emissions. It's not for me to comment on what they did or didn't take into account in setting those budgets. They will obviously monitor emissions in accordance with those budgets. And second, we do have the analysis that the government has undertaken that's contained in the Jet Zero document and by the DFT, which shows that there can be growth in the aviation sector that is consistent and would not undermine the government's climate change targets.
Do you recall Dr. Osendialand saying to me and agreeing with me that the Jet Zero consultation illustrative trajectories should be given limited weight? Do you remember that?
I don't recall him saying that it should be given limited weight.
Okay, well, we'll come on to see what you think about it later. But what you're saying is that the cumulative assessment that you rely upon as demonstrating that further airport expansion is consistent with the attainment of the 6 carbon budget or net zero 2050 is that in the Jet Zero consultation.
That's not what I said.
Right. So
No.
where is the cumulative assessment then that you rely upon, Mr. Mellon?
We have, the test is whether we will have a material impact, whether our emissions will be so significant that we have a material impact on the government's targets. It's not for us to undertake that cumulative assessment. The government has set its targets. The government has undertaken an analysis through the Jet Zero consultation.
Right. So I'll ask the question again because you didn't answer it, I'm afraid, second time. Where is the cumulative assessment that you rely upon in the
No, he
evidence
did
before this inquiry?
answer it. He said we don't rely on one.
Right.
Yeah, I don't rely on a cumulative
He
assessment.
said it's not for us to undertake an
I see.
assessment. We follow the test that's agreed.
So you don't point to a cumulative assessment, and on that basis, the inspectors in this inquiry are, just like the inspectors in the A38 scheme, unable to conclude on the basis of an assessment of cumulative emissions that a grant of planning permission would be consistent with the UK's climate change obligations. That must be right.
I completely disagree with that.
In the absence of a cumulative assessment, Mr. Melling, how do you determine whether the carbon emissions associated with this scheme are material or not?
I think there's two key elements, in my opinion, and I think this was the opinion of Dr. Rosen Ireland as well, and he made this quite clear, that we need to take into account. The first is the scale of emissions relative to the sixth carbon budget, and the scale of emissions from this development, from aviation emissions, would be incredibly small. So that's the first point. Second point is that we also need to take into consideration the target is legally binding on the government, so the government has to meet that target, and that there are a range of measures which are explored by Dr. Rosen Ireland in his evidence, with which the government can use to meet its climate change obligations.
The simple position is this, isn't it? Without a cumulative impact assessment conducted by government, there is no context in which you can judge whether or not any amount of additional carbon emissions is material.
I disagree with
Right.
the fundamental basis of that assertion. And I think
And-
if you just let
Yeah.
me finish, if you took that to its logical conclusion, for any development, you would need to consider all emissions, so not just aviation development, any development, you'd have to consider all emissions according to your hypothesis to come to a conclusion in terms of whether the emissions would be so significant as to materially affect the UK government's targets.
No, Mr. Melling, what you would need is an exercise just like the one that was conducted at MBU to be adopted by government to identify the scale of expansion of airports or of roads or of whatever as being consistent with the attainment of the climate change targets. That's all that's needed.
I disagree. I disagree. The government has, well, first of all, as I said, we've demonstrated that our emissions would be very, very small as a proportion of the sixth carbon budget. But secondly, the government has the measures, the tools it needs to meet its targets. And it is consistently reiterated that, as Dr. Rosen Ireland, I think, put it quite neatly, that there is a carbon cap, but there is not a passenger cap.
The position is that, as in the A38, the contention that the development gives rise to only a small amount of additional carbon emissions as a percentage is insufficient to provide the certainty required to know that granting permission will still enable achievement of climate change targets. That's right, isn't it?
I disagree. In that case, I'm not familiar with the case here, so let me just point that out. But secondly, they're saying that the applicant hasn't demonstrated, so the test, it hasn't met the test to demonstrate that this development will or will not materially affect the ability of the government to meet its targets. We have done that test. Dr. Osland sets that out in his evidence.
Right. Back to the A38 decision letter then, please. Let's just have a look at what was argued there. We can see that we already saw that the Highways England already argued that they were a very small amount of carbon emissions. You remember that? If we turn, please, to page 259 and paragraph 415.116.
So 415.
0.116,
116.
second paragraph from the bottom. We agree with the Derby Climate Coalition, FOED, I think that's Friends of the Earth, and others, that the emissions from the proposed development should not be seen in isolation. The applicant was not able to provide an assessment of cumulative impacts of the proposed development with other highways developments, particularly given its approach of assessing the proposal against UK carbon budgets. The approach doesn't appear to conflict with current government policy, and the contribution may be relatively small, but we're not convinced that the applicant's approach sufficiently considers cumulative effects with other projects or programmes. In our view, an appropriate assessment should, as is normal practice for the assessment of cumulative effects for other matters, adopt a reasonably consistent geographical scale. An example of that would be to consider the RIS1 or RIS2 programmes, of which the proposed development is part, against carbon budgets. And the applicant said that had been undertaken. That's the reference to what the DFT had done. And based on the above, we're not able to reach a conclusion on cumulative climate change effects. They're rejecting the argument, the very approach that you're putting forward to this inquiry, aren't they?
I can't comment on the specifics of this case. However, to undertake such a cumulative assessment, it's a global receptor, and you would need to obviously consider it in the context of the 6th carbon budget. And that would require you to consider all development, not just in this case highways. And how would you form a logical boundary to geographical boundary? Where do you stop with such an assessment when it's a global receptor? What we have done is test whether the emissions from this development would be so significant as to materially affect the ability of the UK government to meet its commitments. That is the test, and that is the test we have applied. And in doing so, we've looked at the measures that are available to the government in the aviation sector, which is an important distinction here. In the aviation sector, the measures that are available to do it to ensure those targets are met. And the government is quite clearly confident. You can see quite clearly the direction of travel from in numerous statements by government, in the decarbonisation plan and in Jet Zero, that it is confident that there is no need to apply a capacity constraint. It's confident that those targets can be met.
You'll remember I put to Dr. Island that aviation cannot attain net zero without reliance on greenhouse gas removal measures. And I put to him that the proportion of the capacity that those GGR measures would provide that would be available to the aviation sector hasn't been identified by central government in a context where many other sectors will be competing for that capacity. And given that position, we simply do not know as we sit here what the government is going to decide in terms of the capacity that will be available to offset emissions from the aviation sector in the future, do we?
These are matters for the government to decide.
Yes.
There is a target. We've applied the test. We have concluded that our emissions would not be so significant as to affect the government's ability to meet that test, taking into account the other measures that are available. It's not for me to decide how the government are going to meet its targets, but clearly the government has made its position quite clear that they won't be adopting a policy of capacity constraint. That isn't current government policy.
All right, I'll come on to that in a second. Can we go to INQ 62, please? This is the letter of the 6th of September 2021, so the start of this month from the Secretary of State.
You just have to bear with me a second, sorry,
Sure.
while I get to that.
And the second page of that,
Sorry, is it 62? Sorry.
62, yeah.
62. Just, yeah, it's just coming up now. Yes.
here we can see that the Secretary of State has considered the question of whether or not to review the AMPS should be, he says that the question of whether or not to review the AMPS should be considered again after the Jet Zero strategy has been finalised. He says this sets out proposed policies that will be needed for aviation to meet net zero emissions by 2050. These policies will influence the level of aviation emissions the sector can emit and the cost of flying in the future.
Yes, that's what it
Right,
says.
so from that we can see that the policies that are needed to ensure aviation will meet net zero commitments in 2050 is not yet determined.
So can you just repeat that question?
The policy that will be needed for aviation to meet net zero emissions by 2050 is not determined.
I disagree. I think if that was the government's conclusion, then they would have revoked MBU. And actually, in this case, they conclude that they don't feel at this time there is a need to review the ANPS.
Right, so what you're saying is that where the Secretary of State says that Jet Zero sets out proposed policies that will be needed for aviation to meet net zero emissions by 2050, he's got that wrong because they're already in place.
The measures are in place.
Right.
Jet Zero, at no point does Jet Zero set out any, the government, it makes quite clear that it's not the government's intention to follow a policy approach of restricting capacity.
So Jet Zero doesn't set out proposed policies, is that what you're saying?
No, it sets out proposed policies, but not a
Right.
demand, not a capacity constraint policy. The government's quite clear on that.
Are the policies in the Jet Zero consultation paper policies that will be needed for aviation to meet net zero emissions by 2050?
There are a range of different pathways to how the government could meet its targets, but clearly the government is confident that it can meet its targets without employing a capacity constraint. That is why it has constantly reiterated its making best use policy position and has confirmed in Jet Zero and in subsequent correspondence that it has full effect.
Next sentence, please. These policies will influence the level of aviation emissions the sector can emit. That implies, doesn't it, that at present the level of aviation emissions the sector can emit consistent with net zero is not yet determined.
it implies that there is, as Dr. Osand-Island put it, that there is an emissions cap, but not a passenger cap.
I'll put the question again. That first part of that sentence implies that the level of aviation emissions the sector can emit consistent with net zero is not yet determined, is it?
We have the 6th carbon budget, so there is a ceiling there, isn't there?
I'll move on. It also says that the policies will influence the cost of flying in the future. You see that?
Yes, that's correct.
So that is also, by inference, we can see that at present, because the policies are not yet determined, the cost of flying in the future is also unknown.
I guess the cost of flying in the future is always unknown, but we've taken that into account. Mr. Brass has taken that into account in the forecasts. The forecasts that have been accepted by the councils on witness.
And we can see from this, from the Jet Zero consultation and the issues that it raises, that the government has not taken any adopted policy view on whether any restriction of capacity or growth may be necessary in the future. That decision's not been made yet, has it, Mr. Melling?
I think, yes, actually, I think it has. MBU sets out that emissions from aviation are a matter for national government to control.
I see.
So first point. Second point, making best use still has full effect. And the third point, I think that the decarbonisation plan, which is policy, refers to emissions reductions through technological innovation. It doesn't mention capacity constraint. In fact, it says something along the line, I can't remember the words verbatim, but we don't want to stop people doing what they do.
Right. Where do I find a policy statement post the decision to seek the attainment of net zero 2050, post the decision to adopt the 6th carbon budget, and post the decision to include international aviation in domestic targets? Where do I find a policy statement after those points in time in which the government states in terms that it has determined that no restriction on growth of the aviation sector will be required in order to meet those targets? Where?
It's a statement that the MBU still has full effect.
Right. So, and that's the statements in the footnote.
Not just in the footnote, in other places as well, which I alluded to in my
Right.
evidence.
So we've got the footnote of the consultation paper. That's a statement of policy, is it?
Yes, it is a statement of policy.
Right. Okay. And
That's separate from the consultation. That is a statement of policy in the footnote.
And the other places where this is stated?
So I think I took the inspectors to this earlier. So this was the DFT's letter to the council. I'll have to. Do you want me to find the reference to that?
No, it's fine.
It was.
So in a letter written in response to a letter from us, that's a statement of policy too, is it?
It confirms the policy position.
Do you not think it's rather odd to have a statement of policy in a private letter to a council?
It's not a private letter.
All right.
So I wouldn't, and the footnote in Jet Zero isn't a private letter.
Okay.
And third, it hasn't taken the decision to revoke making best use. In the same way, it hasn't taken the position to review or revoke the ANPS. In the same way, it hasn't taken the decision to impose a moratorium on airport development.
So because there's been no decision to revoke MBU, we're to infer into that the government has determined that no restriction on growth in the airport aviation sector will be necessary in order to attain net zero 2050 in the sixth carbon budget. That's what you're saying, is it?
Yes.
Right. Thank you very much. That's helpful. Now, that position is intriguing, since Dr. Rosand Ireland, in answer to questions from me, agreed that going forward he couldn't rule out the possibility of capacity constraint, or indeed the need for a beauty parade to be able to select between airports. You recall that?
I think what Dr. Rosand Ireland said, Dr. Rosand Ireland applied the test that has been agreed amongst the parties. The test, sorry, I sound like a broken record, and I apologise for that. But the test that's set out in the ANPS that's been agreed, he applied that test and confirmed to you that on the basis of that test, the development wouldn't have a material impact on the government's targets.
He said in terms to me, and this is the second time I put it to you, and we can all check the video, he said in terms to me that he couldn't rule out capacity constraint, and also that he couldn't rule out the need for a beauty parade between airports as a result. He said in terms, didn't he?
I can't recall those exact words.
Okay.
If he did say that, we are talking there about a different test. That's not the test that we're looking at here. The test, is the one that has been agreed. The government will obviously keep under review its policy position. We know what the policy position is now in terms of MBU, and that policy position could, like any policy, change in the future.
If it's the case that the policy that is needed for aviation to meet net zero by 2050, or indeed the sixth carbon budget target, is not yet formulated, and if it's the case that at this stage one cannot rule out the need for a restriction of growth, or indeed a need for a beauty parade, to grant planning permission for the proposed development in this appeal would predetermine issues central to the formulation of that emerging policy, wouldn't it? On that hypothetical basis.
So I'm going to have to apologise and ask if you could just repeat that again. Apologies.
Sure.
I know it's a long question, so
It
sorry
was a
about
long
that.
question, and I'll put it again. If it's the case that the policies that will be needed for aviation to meet net zero 2050 or the sixth carbon budget targets have not yet been formulated, if it's the case that one cannot rule out the possibility of restriction on growth within the aviation sector, and if it's the case that one therefore cannot rule out the need for a beauty parade between airports as to which one should come forward or which should not, granting planning permission for the appeal scheme would predetermine issues central to the formulation of policy, wouldn't it?
I disagree with that, I think, because we're merely speculating on what future policy may or may not be. So I can't accept your premise.
Right, okay, well I've put the point, I've put it twice. The central difficulty that you face, Mr. Melling, is not of your or Bow's making. It is that government has chosen to adopt targets before telling the world how we can achieve them. And that leaves you in the position, doesn't it, of not knowing how aviation is going to be permitted to grow consistent with the attainment of the climate change targets, doesn't it?
No, I don't have any difficulty. It's clear to me that the government has a range of measures which will ensure that it is able to meet its targets. Measures such as the UK ETS, which it's quite clear, Dr. Osland-Island referred to that in his evidence. So no, I don't accept that.
Right, okay. Well, if the government, in formulating its policy at some point in the future, decides that, in fact, there isn't sufficient capacity to enable all airports to grow as they wish, and we've been through the numbers with Dr. Osland-Island, if they do have to limit which airports grow and which do not, that is something that they've already done in the past, isn't it?
They've already done it in the past?
Yes.
Can you point me to that?
Yes, I can. The Airports Commission was set up to choose which of the airports in the southeast would have an additional runway. And they went through a process and they decided and adopted the ANPS that Heathrow should be the airport that grows, and not Gatwick, and not Stansted, and not an estuary airport. So government has already decided between airport expansion proposals and is prepared to adopt policy to support those decisions. That's right, isn't it?
There was a number of factors that the government took into account in determining which option it preferred. And also, that doesn't take away, even then, the test. I keep coming back to the test, the agreed test in the ANPS. Even Heathrow needs to demonstrate that its emissions won't materially affect the ability of the UK government to meet its targets.
Indeed, but the central point, I mean, we heard about North Korea, if you remember, but the central point is that directing which airports can expand is something the government is prepared to do when required and has done. That's right, isn't it?
It has done that in terms of, yes, capacity in the southeast. It's not doing it here. That's not current policy.
All right. In terms of Jet Zero and the weight to give it, we know that is, sets out an emerging policy position on which consultation has been undertaken. Yes?
Yes, that's correct.
And the consultation stage has closed, but we don't have any response to those consultations published as of yet.
Not as yet, no. Not that I'm aware of.
So it's a bit like having undertaken the issues and options stage of a development plan. It's the first publication of thoughts on how policy might be formulated, and we've got to the end of our issues and options consultation, but we haven't responded yet with any thoughts. So we're at a reasonably early stage in the consultation process. Would you accept that?
No, I don't know if I follow the comparison with the development of a local plan. Mm-hmm. What Jet Zero does, it sets out a range of ways that the government could meet its targets, none of which, so there were no options, no indication of a preferred option, that one of those would be capacity constraint.
And the consultation paper is controversial, isn't it?
That may be your view.
Well,
not my view.
It's not your view, okay. If we take a step back, it's right, isn't it, that the there are numerous groups at numerous airports around the country opposing expansion of airports.
Yes, that's
Yeah.
that's correct.
And it's right, isn't it, that most, if not all, have written in consultation responses objecting to the approach in Jet Zero.
I couldn't comment on that. I haven't
okay, fair
reviewed
enough.
all the consultation responses, so I'd have to take your word for that.
In terms of the approach which is taken in the Net Zero consultation paper, we explored with Dr. Rosalind Ireland the extent to which it examined the likelihood of its policy approach attaining the climate change targets, and it included, of course, us understanding that the DfT explained they'd done no appraisal against the sixth carbon budget at all. Would you accept this, that the Jet Zero does not contain any assessment of the likelihood of its policy approach attaining climate change targets, and so is inconsistent with the approach required in the statutory duties to ensure that climate change targets are attained?
My reading of Jet Zero is that it identifies a range of options that would be available to it and that could meet its targets.
Yes, that wasn't my question.
Sorry, if you repeat the question,
Yeah.
sorry.
Would you accept that Jet Zero doesn't contain any assessment of the likelihood of whether its policy approach would attain climate change targets, and so is inconsistent with the approach required in the statutory duties to ensure that climate change targets are attained?
I think it does demonstrate that those different pathways or scenarios that are looked at can achieve its targets.
All right, thank you. Now let's, I just want to ask you about policy and whether it can become out of date.
Yes.
You accept, don't you, that national policy can become out of date where it's undermined by a change in circumstances since its adoption?
Yes, of course.
Yeah.
And in those circumstances, the government will revoke the policy, review the policy.
And even before a review, it is open to a decision maker to consider whether national policy has in fact become out of date as a result of a change in circumstances since adoption. That's right, isn't it?
I don't think it is. I think
Okay.
my understanding of the position is it's not within the with respect, it's not within the remit of this inquiry to challenge the merits or otherwise of government policy. That is my understanding,
Yeah, but
which I think is supported by case law, I think.
all right, let's try this way. Where a policy is out of date, that reduces the weight that a decision maker can rationally ascribe to that policy. That's right, isn't it?
I don't know. In terms of national policy,
Yeah.
government policy,
Yeah.
I think government policy has full weight. And in terms of, which
Right.
I know we're going to go to in making best use, the government has confirmed it has full effect.
Okay. In that case, let me just take you to something then. Let's go to INQ 42. This is the Department for Transport response to the North Somerset letter, and if we go in this document, please, to I think page 24. Just see if that's the right page. Yeah, top of page 24 of this document. So the right-hand column is the response from the department. It says MBU forms part of the overall framework of planning policy support for airport development. other statements of government policy may be material when deciding applications. It's for the decision maker to determine the appropriate weight to attribute to relevant policy according to the stage of preparation and other factors. Further policy and guidance on planning decision making can be found in the MPPF. So what the department is saying is that it's for the decision maker to determine the weight to give to MBU. That's what they're saying, isn't it?
No, I think, well, I guess it depends how you read that statement. So I think it starts off, if we go up a couple of paragraphs there, so the second paragraph, and it says, as stated in footnote 39 of the Jet Zero consultation, MBU continues to have full effect, so full weight is my reading of that. Just to answer your question, when we come to this part, it says other statements of government policy may be material when deciding applications. It is for the decision maker to determine the appropriate weight to attribute to relevant policy. So I assume that that is referring to other statements of government policy, and in that case, it is, of course, it's for the inspectors to consider what weight they will apply to those other statements of government policy.
Okay, so what you're saying is that the department is saying that for other statements of national policy than MBU, it's for the decision maker to determine the weight.
That's what they're saying here.
MBU, it's not.
Yes, that's what they're saying.
That's
here.
what they're saying. So MBU
That's my reading of that.
MBU
that
has a very particular status that means that a decision maker doesn't have any discretion as to the appropriate weight to give to it. That's the approach you adopted. Is it?
Yes, that's my reading of that.
All right. And so following your approach, what that means is that you don't have to consider whether policy is up to date at all. It's just an irrelevant exercise.
In terms of MBU, the government has been quite clear that it has full effect.
What you're saying is that in terms of MBU, whether it's up to date or out of date is an irrelevant exercise. It's just something
The government clearly doesn't think it's out of date.
It's something the inspectors don't have to even consider.
No, because the government have said it has full effect.
I see. And so because the government says it's full effect, what you're saying is that the inspectors have got no discretion as to weight whatsoever.
My opinion is full effect means full weight.
All right. Let me put a different hypothesis to you, that full effect means that it is still adopted policy, but that, like all adopted policy, whether development plan policy or national policy, in every case, it is for the decision maker to determine the weight to give to that policy in the circumstances of the case. And in that circumstance, if that is right, what they're actually saying is that it's adopted and to be given full effect as adopted policy, but the weight is still for the decision maker to determine. Would you accept that?
I disagree with, my reading is different, and I think we'll just have to probably agree to disagree on this, but my reading is it has full effect. I then go on to my opinion, as I set out in my evidence, is that it has significant weight. So it has full weight, and I say it then has significant weight.
Just so that I've got it clear, you don't in your proof, do you, cite any authority for the proposition that national policy is somehow different from any other policy and a type of policy which inspectors do not have to consider the weight to be given to?
I don't specifically deal with that matter in my proof of evidence.
Apart from MBU, is there any other policy at the national level that the inspectors are barred from considering the weight of?
I'm just talking about MBU, the policy position of making best use.
Okay, so just MBU. So the APF...
No, I said the policy of making best use, which is contained in the APF and in the policy document itself, MBU.
Okay, so we're getting somewhere now. So in terms of the APF, that too is in this category of policy which the decision maker is not permitted to determine the appropriate weight of in their decision-making process. Is that what you're saying?
No, what I'm saying is that the government's policy generally of making best use
Yeah.
should be afforded full weight
Right.
in a decision.
I'll put the point again. You already explained that NBU is in this special category different from other national policy. I'm now exploring with you whether the...
I haven't necessarily said it's different. I've just said the government has confirmed that it has full weight.
Right. Well, we've got your answer from before. We can look back on it. In terms of the APF, are the inspectors in this appeal entitled to determine the appropriate weight to attribute to that policy in the circumstances of this case, or not?
I think the inspectors have got to take what the government have said, that in terms of making best use, that full effect, full weight should be given to that policy. And my opinion, my view is that full and significant weight should be given to the APF.
So if the inspectors were to conclude that the APF were out of date in some way, they would still have to give it full weight, to use your phrase. That's your approach, is it?
I don't think it's the position of this inquiry to challenge the merits or otherwise of government policy.
But it's not about challenging the merits, though, is it, Mr. Melling? This is about determining the weight that you give to policy. It's not a challenge to the merits. You still apply the policy, but it's the question is how much weight you give to that policy in your determination.
I think this is a way of the council's case is to challenge the policy, and I don't accept that, and that is my position.
Right. Okay. Well, I mean, let's take a different approach. Let's think about a case where we're just applying the MPPF, right?
Yes.
And the MPPF at paragraph 11 has a very particular way in which you take decisions within its context, doesn't it?
Can we go there?
Yes.
Yeah.
Absolutely.
So are we looking at the presumption in favour of...
We are, yeah.
With that? Okay.
We're looking at the decision-taking part.
Yes.
And we're looking at D in particular. So that says for decision-taking, this means where there are no relevant development plan policies, or the policies which are the most important for determining the application are out of date, granting permission unless. So that approach requires a decision maker to determine whether the most important important policies for determining the application are out of date or not, doesn't it?
Yes, in the context of development plan policies, we're talking about government policy here. That's an important distinction, I feel.
Right. So the approach to, well, let me just put the next point. Where a development plan policy is out of date and you apply this approach, decision makers routinely reduce the weight given to those out of date policies, don't they?
Development plan policies, yes.
Yeah.
So in this context, my understanding of this is it's really about local authorities being able to demonstrate that they have a 5-year housing land supply.
Yeah. So,
which I think is actually set out there at footnote 8.
So the concept of applying a policy that is out of date, because they're still applied, aren't they, through the Section 38 process? They have to be.
Yes, they're still taken into account.
So what inspectors routinely do is identify development plan policies that are out of date, and then they take them into account, but they give them limited weight.
For development plans? Yes.
And so in respect of national policy, which is out of date, it too can be taken into account, and it too can be given limited weight, can't it?
I disagree. I think here we're talking about development plan policy, which is quite distinct from national policy, and in any case, my position is that MBU, the government's policy of MBU, is not out of date.
Right, okay. And indeed, your view is that it can't be out of date because you don't ask yourself that question. That's right, isn't it?
It's not for
Yeah,
this inquiry to consider the merits of that policy.
yeah.
The government it's restated that it has full effect.
And you'd say the same in respect to the APF, presumably?
Yes.
You just don't consider whether it's out of date?
It's not out of date because it is current extant. It's extant policy, so it's not out. If the government felt that the APF was out of date, then surely, given that the policy was published in 2013, it would have revoked that policy. It's chosen not to do that. It's not revoked the policy.
Okay. So if we go back to...
And sorry, if I can just add to that, that's
Yes,
despite the fact that the net zero target was introduced into the Climate Change Act in 2019, and here we are sort of 2 years later, and the government still hasn't revoked that policy. It is still up to date and extant policy,
Right, okay.
which the government says should be afforded full weight.
You understand the nature of the case that the council's presenting. Just let's go back to the department's letter that we were looking at earlier, and that's in INQ 42. I just want to finish this point off, and then I think it might be time for a break. We were looking at page 24. If we turn back to page 23, at 24.3, they refer to some forthcoming work from the Department for Business, Energy and Industrial Strategy. And then it says that the government has set out its support for airports making best use of their existing runways in its policy statement, making MBU. It remains current policy and continues to have full effect. As stated in footnote 39, MBU continues to have full effect in relation to planning decision taking. Now, just like the development plan that we were discussing, a development plan which has policies that are out of date remains in full effect, doesn't it?
The development, we're talking across purposes, that's a development plan, this is government policy. I think I've made my position quite clear on this. I consider that MBU continues to have full weight.
And the word full effect simply means that the government has stated that the APF and MBU are material considerations to be given weight in a decision, but, and this is the key but, the weight to be given to those policy statements is a matter for the inspectors to determine, isn't it?
With respect, I disagree. I think full effect, I read that as full weight.
All right.
But clearly this is an area of disagreement between the parties and with me as well.
Even if the government is to have been taken to have stated that APF and MBU are of full weight, if the inspectors consider that nevertheless on the evidence before them those policy statements are out of date in some respect, it is still open to them as a matter of law to adopt a different view from that expressed by government, isn't it?
As I said, I don't actually think it's the position of this inquiry to question the merits or otherwise of national policy.
Right, so your position is that even if the inspectors consider that MBU or APF is out of date in some way, it is not open to them to ascribe lesser weight to those policies in the planning balance. That's your position.
So I think it's a hypothetical position because it's quite clear that they're not out of date. That is my view.
Okay. And just so that we deal with that last point, the government's not produced or referred to in footnote 39 or in the letter response any evidence which demonstrates that the policy approach in MBU or the APF about best use of existing runways is up to date, notwithstanding the adoption of the sixth carbon budget or net zero 2050, has it?
So can you just repeat? Apologies.
The government doesn't refer to any evidence that demonstrates that MBU or APF is up to date, notwithstanding the adoption of the sixth carbon budget or net zero 2050.
The government has had the opportunity to revoke those policies if it felt they were out of date. It's chosen not to. It's not for me to question what the government has or hasn't taken into account in that decision.
Right.
Secondly, sorry, just to add, it has produced the Jet Zero consultation and the evidence and analysis work that goes alongside that document as well, which does demonstrate that that there can be further growth in aviation without a capacity constraint being imposed.
All right, thank you very much. I'm going to get a break there, and I've got many more questions for you after the break.
I look forward to it.
Okay, thank you very much. We'll reconvene at 3:30. Thank you. 3:30. Okay, welcome back. Mr. Taylor, I think you've had about an hour and 10. You estimated 3.5.
Yep.
Is there, where will we be at 5 o'clock today?
I will have another half an hour to go.
Okay. Right, well, yeah, worth a try. Okay.
I'm going to move next, if I may, to look at the role of national policy in the Section 38.6 approach context. We know that Section 38.6 requires consideration of whether a development accords with the development plan, and it then gives rise to a presumption in favour or against grant, subject to consideration of material considerations.
Yes.
Yeah? And the MPPF, for example, is a material consideration that one puts into that Section 38.6 approach.
Yes, that's correct.
And as we've seen already, the MPPF contains an approach in paragraph 11 relating to the presumption in favour of sustainable development, and you apply that approach, and where the MPPF supports the grant of planning permission, that is then a material consideration which is given weight in the Section 38.6 approach.
Yes, in the balance, yes.
Yeah. And similarly, if there's conflict with the MPPF and the MPPF doesn't support grant, then that's put into the balance as weighing against grant, isn't it?
Yes, that's correct.
And MBU, that is also a material consideration, isn't it, in the Section 38.6 approach?
Yes.
And I think you said in your evidence in chief that in essence, the APF, MBU and Aviation 2050 give rise to, in principle, support for aviation growth, subject to demonstrating that benefits outweigh harm.
Yes, there's in principle support,
Right.
but I agree with Mr. Gertler that that's not unconditional support.
Yeah.
There is a need to also take into account in the balance those adverse impacts as well.
Yeah, and so what is required is to undertake a balancing exercise, and where the benefits outweigh the harm, then in your Section 38.6 balance, you get the support of MBU and the APF and Aviation 2050, don't you?
No, that's not the approach I've applied. So the approach I've applied is there is support for making best use. So that's on one side, but then in accordance with the policy, I've also balanced that against the impacts as well.
Right. In that case,
Sorry, just to expand on that, because otherwise, if you're in a position where MBU only applied after you'd done that balancing exercise, then I don't see how it would have any sort of relevance to the decision, because you've already undertaken that planning balance to consider the cost versus the benefits.
well, what MBU requires you to do is to balance the benefits against harm. And if you conclude that the benefits outweigh harm, then MBU is a material consideration in the Section 38.6 approach that weighs in favour of the grant of planning permission. That's how it works.
That's not how I have applied it.
Right.
No, so I have taken into account the principle of making best use, so making best use of capacity as a benefit that weighs in favour of the application, but then I have also balanced that against the adverse impacts
Yeah.
of the development, as you would in any planning balance.
What you've done is to weigh as a material consideration in your planning balance support for growth of aviation, full stop. And you've also then gone on to look at a balance.
I've looked at the government's policy of making best use, so not support for aviation full stop, but making best use of existing airports. And then I've then weighed that policy against the adverse impacts.
Yes.
That's the approach I've taken in the planning balance.
In your balance, you've included freestanding policy support for aviation growth that is not dependent upon the outcome of a balancing exercise. That's right.
No, I've undertaken a balancing exercise. So on the one hand, I've taken into account the in-principle support for growth, but I've also taken into account
Yeah.
the adverse impacts.
The other way of looking at this is that when you're applying MBU, if the outcome of your balance exercise is that costs outweigh benefit, the non-compliance with the approach in MBU weighs as a material consideration against the grant of planning permission in the Section 38(6) approach. That's right too, isn't it?
Sorry, I'm not following. I think just to explain, if in a hypothetical situation, my planning balance would have concluded that the adverse impacts of growth were so significant that they outweighed the benefits, including making best use of the airport. In that situation, then obviously my planning balance would have come to a different conclusion.
You see, what I'm struggling with here, Mr. Belling, is that your own words in your evidence in chief were that there's in-principle support subject to. What
Yes.
you have done is to put in the balance support that isn't subject to anything.
No, there's the support, goes on the one side, but then I have also taken into account the adverse impacts on the other side of the planning balance.
If, on the other hand, the way that you approach is to carry out the balance as I've put to you, and if the benefits outweigh harm, then you place MBU as a material consideration weighing in favour, or if harm outweighs the benefits, you place MBU in the Section 38 approach as weighing against the grant. That approach is one which is enables and gives effect to a policy of support subject to the outcome of the balance, isn't it?
I disagree. In your interpretation, you have already conducted the planning balance. You've already come to a conclusion as to the merits of the scheme and whether planning permission should be granted. So in that instance, making best use would never be able to have any effect on the planning balance because the planning balance has already been undertaken.
No. What's been undertaken is the balance required by MBU to see whether MBU supports, just like one undertakes a balance in relation to the MPPF to apply paragraph 11.
I disagree because you by that logic, you're undertaking the planning balance. So the MBU would never apply. I don't follow the logic of that assertion. I think actually just thinking back to the examination of Mr. Gertler, I think he accepted that the support for airports making best use of their capacity was something that did weigh in favour in the planning balance, so was a benefit. I think that was Mr. Gertler's position under cross-examination, and I would agree with that position.
I'm exploring with you the legal approach to Section 38(6) and how we identify what is a material consideration and MBU in that context. And if it's right that if benefits outweigh harm, MBU is given weight in favour of grant, then the in-principle support is given effect in the planning balance in that way. And if it's right that where costs outweigh benefits, MBU, the policy approach to MBU is not satisfied and MBU is weighed in the balance against grant, whichever outcome, MBU is given full effect and is not redundant. That's right, isn't it?
No, I disagree. And the policy of making best use is not able to be taken into account. The benefits of making best use can't, by your logic, have any influence on the planning balance because you've already undertaken the planning balance. You've already come to a conclusion before you apply
No, in
making
fact,
best use support.
in fact, Mr. Melling, the approach you're adopting renders the MBU balance determinative and doesn't apply section 38.6 at all.
I completely disagree. The support for airport growth is something that weighs in favour, so making best use, but you do need to balance that against the adverse impacts, which is exactly what I've done in my planning balance.
All right, thank you. I'll move on from that. On to sharing the benefits. Now, in the APF at page 8.
So you just have to bear with me while I
Sure.
while I get there.
Let's get the APF up because it's important.
Sorry, which page was that?
Page 8.
8.
It's in the executive summary. Paragraph 3, it explains that the APF is underpinned by two core principles, and the first of these is collaboration. By working together with industry regulators, experts, local communities and others at all levels, we believe we will be better able to identify workable solutions to the challenges and share the benefits of aviation in a fairer way than in the past.
Yes, I see that.
So,
yes.
so this is introducing a change of policy designed to share the benefits of aviation in a fairer way than had happened previously. Yes?
Yes, it says, as I think Mr. Gertler agreed in cross-examination, this is a general principle, yes.
Right, thank you. And just while we're looking at this topic, can I take you please to MBU, which is CD 604, and to page 9.
Yes, I'm there.
Thank you.
Oh, sorry,
Page
page 9
of
of
the PDF.
Yeah, got that.
Paragraph 122.
Yes.
Halfway down it says, as airports look to make best use of their existing runways, it's important that communities surrounding those airports share in the economic benefits of this and that adverse impacts such as noise are mitigated where possible. You see that?
Yes, I see that.
And so where it's, that's stated in the context of the previous sentence about the government recognising the impact on communities living near airports. And it understands their concerns over local environmental issues, particularly noise, air quality and service access. So we can see there a very clear statement that it is those that live near the airports who are subject to impacts with whom the economic benefits are to be shared.
It doesn't define, sorry, it says that communities should have a share in the benefits. So I agree with that, but it doesn't define what the sort of geographic extent of those communities. It's not specific there.
Okay, well let's just unpack it a little bit more then. in the first sentence, it recognises the impact on communities living near airports. Yes?
Yes, but not,
Yeah.
doesn't say immediate, adjacent to the airport or anything like that. But yes, that's what it says.
Right. It's talking about those subject to the impacts, namely noise, air quality and surface access impacts, isn't it?
That's what it says.
Yeah. And in the next sentence, it says it's important that communities surrounding those airports share in the economic benefits and that adverse impacts such as noise are mitigated. The phrase communities surrounding those airports is consonant with the phrase communities living near airports. It's saying that those who are subject to the impacts are to have a share in the economic benefits. It's very clear.
Sorry, I'm just reading it again. It's saying that communities surrounding those airports share in the economic benefits.
So are you saying that that phrase is used in a different way from the phrase communities living near airports in the first sentence, such that they're distinctive groups of people? Is that what you're saying?
What I'm saying is it's not geographically specific
'Cause
in terms of what it defines as a community. So as I think was agreed with Mr. Gertler in cross-examination, there's a need to, there's a need to recognise that the benefits, the economic benefits that are referred to here, and all types of effects, to that extent, they'll have varying geographical impacts. So things such as air quality impacts may be very localised, noise may be geographically wider, and economic benefits, some of those may go to people immediately adjacent to the airport. Some of those will be much wider than that, but that's still, you would still say in this case, somewhere like Weston-super-Mare, for example, is still a local community to the airport.
So I'm putting to you that the phrase the communities surrounding those airports in the second sentence, that's representing the same group of people identified in the first sentence as communities living near airports who are subject to the impacts. They're the same people. That's right, isn't it, Mr. Melling?
I don't think that's what it is saying.
Okay.
Sorry, I think
Right,
there's
let's move
two
on
separate sentences there. I think one is saying communities living near the airports, and the other one is saying communities surrounding the airport. It's not defining what communities are.
Right. Okay, so that's very helpful, thank you. Let's go back to the APF then. Lost it now. And I'd like to take you to page 55. And we've got, that's page 55 of the PDF, paragraph 3.1. We can see that it refers under the heading context that whilst the aviation industry brings significant benefits, there are costs associated with its local environmental impacts which are borne by those living around the airports, some of whom may not use the airport or directly benefit from its operations. So it's talking about those living around the airports bearing the burden of the impacts, but not benefiting directly from the operation of the airport, isn't it?
Yes, that's what it's saying.
Yeah. And if we go on and look at paragraph 3.3, it explains that what the government wants to do is to strike a fair balance between the negative impacts of noise and the positive economic impacts of flights. So it's looking for a fair balance to be struck in that respect, isn't it?
Yes, it's looking. What it's saying is, as the paragraph goes on, it's talking about technological improvements, so not necessarily just economic benefits, but it's talking, as aircraft get quieter, then there should be, then the local communities who experience those impacts should receive a benefit.
Yeah. And then it says this, as a general principle, The government therefore expects the future growth in aviation should ensure that benefits are shared between the aviation industry and local communities. Now, first of all, the phrase "as a general principle," that means, doesn't it, that this policy approach applies generally?
I think this is a statement about the aviation sector generally, would be my view. It's not a development control type policy. It doesn't specifically apply to airport development proposals. It's about the sector in general, the aviation sector, rather than specifically airport development.
Right.
It's a general principle.
Okay, let's just explore that then. For the sector to grow, it needs to get planning permission, doesn't it, or DCO?
Depending on the airport, it may need to.
Yeah.
Some airports may have capacity within their extant consents to grow.
Right, and so if this doesn't apply in the context of granting planning permission, how does the government ensure that the future growth in aviation and the benefits of it are shared between the industry and local communities if it's not taken into account at the development control stage?
It's talking here about innovation in aircraft and the aviation sector more generally.
I see. So it's not talking about what MBU was talking about, which was sharing economic benefits.
MBU referred specifically to economic benefits. This, I think, is more in the context of the benefits of associated with technological improvements.
Okay. If that interpretation was correct, just explain to me how that sits with the first sentence of paragraph 3.3, which states that the government wants to strike a fair balance between the impacts of noise and the positive economic impacts of flights. This balance is about economics as well, isn't it?
Oh, yeah, economics.
Yeah.
In terms of
Right.
the economic benefits of a development and their impacts on local communities, yes, that is
okay.
taken into account alongside
Good.
the technological improvements
So
as well.
when it's talking about sharing the benefits in the next sentence, it's about sharing the positive economic impact of flights, isn't it?
Yes, that's what it
Yeah.
says there.
Okay. So, back to my point, if this general principle isn't applied at a development control stage, how does the government ensure that the economic benefits and the technological benefits are shared between the aviation industry and local communities? What's the mechanism?
That could be through other mechanisms that sit outside the planning system, such as airspace change. It could be through airspace change, those types of mechanisms as well.
How does airspace change provide a local community with a share of the positive economic impact of flights?
No, I mean, that doesn't in terms of economic
Right,
benefits.
so I need an example, please, of a mechanism other than the development control system, whereby the government can ensure that the economic benefits are shared between the aviation industry and local communities. Because I can't think of one. So you tell me.
No, I can't
No.
think of one myself.
Okay, and the reason you can't think of one is because there isn't one, Mr. Melling, and this policy is to be applied at a development control level as a general principle, isn't it?
I still maintain that this is talking about many different types of impacts, and it is a general principle
Yeah.
that applies to the aviation sector as a whole.
And a general principle can be departed from, is to be followed unless there are cogent reasons for departing from that principle. But you don't provide any reasons for departing from that principle, do you?
No, I don't.
No. Okay. And so if we assume then there aren't any reasons for departing from the general principle, and it does apply at the development control level, the only reasonable way to interpret this paragraph is that where it refers to sharing benefits, it's referring to sharing the benefits with those who suffer the environmental impacts of the airport's operation. That's plain as day, isn't it?
Sorry?
It's plain as day that that's the case.
I think that there needs to be an acknowledgement that the geographic scale of benefits will differ. What you define as a local community will differ, as I've explained previously.
The phrase "the local community" in 3.3 has to be construed with the objective in mind and the context of 3.1, namely it's about rebalancing the benefits and sharing those with those who live around the airport, some of whom may not use the airport or directly benefit from its operations. It's perfectly clear that what is being said in 3.3 is that those people, the ones who are impacted, are to have a share in the benefits on a fair basis. That's right, isn't it?
It's saying that the benefits associated with things like technological improvements, it's not defining what benefits it's talking about there. So in some instances, such as technological improvement, there's an opportunity for aviation to share benefits with communities that are directly impacted. For economic benefits, some of those may benefit those local communities, but some of those may benefit those immediately adjacent to the airport, but some of those will also benefit the wider local community. It depends on which impacts you are considering.
Yes, the people embraced in the fair balance are those who suffer environmental impact as a result of the airport's operations, and that will vary depending on whether one's looking at noise at night, noise during the day, or indeed those experiencing adverse impacts from air pollution. They will be different people located in different places. But all of those people who experience environmental impact are, by this policy, to be given a share in the positive economic impact of flights, aren't they?
No, I disagree with that. I don't accept that. I think it depends on which impact we're talking about. I think, as with any infrastructure project that I can think of, economic benefits will inevitably be spread over a much wider area than being immediately adjacent to the development.
The fair balance requires the impact on those people to be identified and the economic benefits on those people to be identified, doesn't it?
I don't agree with that. I think, again, it comes back to my point that you look at the impacts at an appropriate geographic scale.
And there is no economic impact assessment which demonstrates that the people who are subject to the noise impacts of the proposed development, who will be affected by the increase in air pollution compared to the position if permission were refused, would obtain any economic benefit. There's just no evidence at all.
I think, as Mr. Brass set out in his cross-examination, to undertake such an assessment would require, you'd have to look at each individual person and assess whether they're receiving a benefit. I just don't see how, well, I don't think that's proportionate. Secondly, that type of assessment, that was never requested by the council at any stage. during the determination of the application, nor following refusal of the planning application. So, yeah, I disagree with that point.
When you apply for permission for airport expansion, are you required to comply with the APF and MBU in order to gain their support?
Yes, you
Yeah.
need to take those into
Okay.
account.
Now, the position then, in terms of the evidence before this inquiry, is that those living around the airport are subject to adverse environmental impacts, but there is no assessment that demonstrates that those people obtain any economic benefit. That's not a fair share, Mr. Melling. That's not the rebalancing envisaged, is it?
You're just focusing on economic benefit. What is quite clear here in paragraph 3.3 is it's wider than that. We need to look at the other benefits as well.
Yes.
So those benefits.
We're going to do that in a moment.
No, but let me finish. So in terms of noise, there'll, as we've discussed during this inquiry, there will be technological improvements that will deliver a benefit in terms of noise, and that is exactly why the airport is going to reduce the size of its noise contours. So despite growth, the noise contour size is going to decrease, and that's an example right there of sharing the benefits of technological innovation.
What about the 7,000 people who will be subjected to an LA max of 60 decibels at night for between 100 and 199 times as a result of the grant of planning permission, Mr. Melling? Do you think they'll feel that they're getting a benefit from this development?
I can't. You're asking me to weigh up the benefits for individual people, and with respect, I can't do that. I don't think it's reasonable to do it. We need to look at the impacts and the benefits in the balance.
Let's look at sharing the benefits of technological improvement. We've looked at the sentence that begins with as a general principle. The government expects that future growth in aviation should ensure benefits are shared. Then it says this means, in other words, a part of the benefits of sharing means that the industry must continue to reduce and mitigate noise as airport capacity grows. That is envisaging, is it not, the growth of airport capacity with continued reduction in noise levels compared to the point in time, well, compared to the present day, effectively.
No, that's not my reading of that. Indeed, I don't think the APF anywhere. I think the APF acknowledges that there may be adverse noise impacts. So I think that's what that's saying there is that there will be adverse impacts, but over time, those impacts will reduce with technological innovation.
It refers to, it says must continue to reduce. You see that? As airport capacity grows. It's perfectly clear that it is looking for a reduction compared with a point in time in the past, even with capacity growth.
It's saying that the aviation sector as a whole should look to reduce noise. That's what it's saying.
I see.
So there's no requirement here for proposals for the growth of airports to reduce noise beyond the baseline.
It also
That's not stated in the APF anywhere.
It goes on to say, the last sentence, as noise levels fall with technology improvements, the aviation industry should be expected to share the benefits from these improvements. That is, in other words, as noise levels fall from present levels, then present levels, as a result of technology, when the airport industry expands, it is not to use up the headroom that's created by the technological improvement.
I disagree with the council's case on this point. I disagree with the principle of a headroom approach. Nowhere in the APF is the concept of a headroom referred to. It's encouraging the aviation sector as a whole to deliver improvements, but it's not scheme specific. What the APF is doing is promoting a balanced approach.
All right. Explain to me this then. If an airport expansion scheme consumes all of the technological improvement that would be gained at that airport, all of the noise reduction associated with technological improvement, and the airport uses up all of that, it consumes it all, how does it share the benefits from those improvements if it's used them all up?
I'd take a step back from that first of all and just say, how do you define what the headroom is? Before you can apply the test, how would you define the headroom? And I think that would be a difficult undertaking in itself, and there's nothing in here in the APF about defining a headroom, about applying a headroom, about development which goes beyond the headroom shouldn't be allowed to proceed. There's nothing in the APF on that.
Right, and the answer to my question, Mr. Melling?
Sorry, if you repeat the question. I think I answered it, but repeat. Feel free to repeat it.
The point I put to you is that where you have a situation where an airport wishes to expand and its expansion consumes all of the noise reduction that would otherwise be realised from technological improvement, where that's done, how does that airport share the benefits of the technological improvements?
It may be sharing benefits in other ways. It could be economic benefits, as you alluded to earlier. And in this case, if we bring it back to this application, you know, if the noise contours are smaller, if the quarter count is adjusted as it has been, I would argue that that is an example of sharing the benefits of technological improvements.
Mr. Williams's evidence, you'll remember, contained an assessment of people within contours, people sleep deprived, people affected by various indices at 2017. And I went through an exercise with him where we looked at the situation in 2030 compared to 2017, and there were a number of instances where the noise reduction that would otherwise occur if permission were refused compared to 2017 was negated in its entirety. Mr. Melling, you remember that on Mr. Williams's own evidence?
I can't recall that specific line. However, what I would say is the airport, Mr. Williams has demonstrated, this is my recollection, that despite an increase in capacity of 2 million passengers per annum, the noise contours will still be smaller. And we also need to take into account that the airport is proposing an enhanced range of other mitigation measures, such as the enhanced noise insulation scheme, which actually goes beyond, I think, the requirements in the APF and indeed Aviation 2050. So in that way, I would argue is sharing some benefits of growth. That's just looking at noise in isolation.
We also went through an exercise with Mr. Williams in cross-examination that demonstrated that even where noise is reduced compared to 2017, with the grant of planning permission, the airport consumes most, if not all, of the reduction that would otherwise occur. And that's not a fair share of the benefits of the technological improvement, is it, Mr. Melling?
I think you're looking at a specific element here. We need to look at the development as a whole and the benefits that delivers.
No, I'm looking at 3.3 of the APF, the last sentence of which refers to noise levels falling with technological improvements, the aviation industry being expected to share the benefit from these improvements, from the technological improvements, Mr. Manning.
Yes.
That's right, isn't it? That's how you construe that.
I agree with that, but the airport is growing. It's growing, and contours are reducing. That's an example of how the airport is sharing the benefits. It's still growing, but it is reducing the noise contours.
All right,
And that's just looking at noise. So, you know, if we looked at the wider benefits as well, we'd also need to take that into account.
I'm not suggesting that you leave anything relevant out of account in the planning balance, Mr. Melling. I am simply seeking to apply the tests set out in the APF that require a fair balance to be struck between the impacts of noise on health, amenity, quality of life and productivity, and the economic benefits and the technological benefits of the development. And that is a test which we have to consider as part of whether or not to grant planning permission. That's right, isn't it?
I think we need to look at, well, we've been through this. I think my position is clear.
Right. If you don't want to
I think
answer
it's
the
a
question,
general
that's fine.
principle. But nonetheless, even if you accept your proposition, I maintain that the Bristol Airport has demonstrated, the evidence does demonstrate how it is sharing the benefits of growth with local communities.
Yes. Okay. Well, the evidence that you've provided in terms of sharing benefits is to the North Somerset Council area as a whole, and indeed further afield than that. It's not about sharing the benefits with those who are subject to the impacts, Mr. Melling.
That's not what I said. I said economic benefits, as you would expect, will spread over a wider area. So I can give it, you know, we can look at, so there'll be benefits to specific communities, such as the residents of Weston-super-Mare, and I don't think the council would say that that's a benefit that shouldn't be taken into account. I've said that some of the measures to reduce and mitigate noise, they will benefit local communities. Some of the measures to reduce, to improve, associated with the A38 and public transport improvements, they will benefit local communities. So I think I've been quite clear on that point.
All of those factors, Mr. Melling, are to mitigate impacts. They're not benefits, they're the mitigation of the impacts of the scheme.
I disagree with that point. I think there's a couple of examples. I've already talked about the noise contours, so they're reducing despite growth. And the assessment, sorry, the environmental statement addendum and the evidence of Mr. Williams also demonstrates that there will be some noise benefits to some receptors because of some of the measures contained in the scheme. So
Right,
in terms of ground noise, for example.
Policy CS23 next, please. We know that requires the airport to demonstrate the satisfactory resolution of environmental issues, doesn't it?
Sorry, I'll just have to wait till I get to that.
It's CD 5.6, page 97.
Probably should know the page number off the top of my head by now, but yeah, I have that.
Proposals for the development of Bristol Airport will be required to demonstrate the satisfactory resolution of environmental issues.
Yes, that's right.
So if the satisfactory resolution of environmental issues is not demonstrated, then there'll be conflict with this policy, won't there?
Yes, if it's not demonstrated.
Yeah.
I agree.
And so it's not a question of balancing harm against benefit, rather it requires development deliver growth without compromising the environment, both human and physical. That's right, isn't it?
No, I think I disagree with that, and I'll expand on that. I think in determining whether there's been satisfactory resolution, you need, naturally you'll undertake a balancing exercise. So if we look at, say for example, noise, which we've spent quite a bit of time on, you would have to look at the adverse noise impacts and the mitigation proposed, but also the benefits, the noise benefits as well that have been identified in the assessment. So that's just one example. I could suggest others. So, for example, in terms of highways, you would need to look at the adverse impacts, but also the benefits that could be delivered to the A38, and through that balancing exercise, you would then make a judgment as to whether there has been satisfactory resolution of environmental issues. But you would also need to take into account the type, the nature of the development and the scale of development in coming to that conclusion.
All right, let's turn on to policy relating to noise. Now we know, don't we, that the MPPF requires an approach of assessing noise impacts against Lowell and Seoul levels based upon the noise policy statement for England.
Yes, that's correct.
And if we looked at it earlier today, but if we could take out CD 10.4, please, and turn into that to page 9.
So you just have to bear with me, my computer's running a little bit slow. So that's the noise policy statement for England. Just give my computer a while. Let's get there. What page was that, sorry?
Page 9 of the PDF.
Page 9.
Paragraph 224 I want to take you to.
224.
It says that the second aim of the NPSE refers to the situation where the impact lies somewhere between Lowell and Seoul. It requires that all reasonable steps should be taken to mitigate and minimise adverse effects on health and quality of life, whilst also taking into account the guiding principles of sustainable development. This doesn't mean that such adverse effects cannot occur. So what it's saying is that above Lowell, all reasonable steps should be taken to mitigate and minimise adverse effects on health and quality of life. That's the starting point in terms of the mitigation that could be expected where people are experiencing noise above Lowell. Yes?
Yes, reasonable steps, but also taking into account the guiding principles of sustainable
It's not just reasonable
development.
steps, is it? It's all reasonable steps.
All reasonable steps,
Yeah.
but then it says taking into account the guiding principles of sustainable development.
Yeah. And then if we look at the MPPF and we turn in that to paragraph 185, I keep forgetting to write the page numbers down.
So you just have to jumping around a little, just bear with me a second.
It's page 53 of the
MPF, page 53.
yeah,
And what paragraph, sorry?
185.
185, okay.
So this refers to ensuring that new development is appropriate for its location, taking into account its likely effects. It says in doing so, that's to say decision makers, applicants, should mitigate and reduce to a minimum potential adverse impacts resulting from noise from new development, and to avoid noise giving rise to significant adverse impacts on health and quality of life. So again, effectively that is the policy hook in the MPPF for the proposition I was putting to you before, that above Lowell, all reasonable steps to be taken to mitigate and minimise adverse effects.
Yes, it says
Yes?
reasonable steps, yes.
Right. Okay. And you refer in your proof, I think, to a substantial package of measures proposed by Bristol Airport Limited to mitigate noise impacts.
Yes, that's
Yeah.
right.
And am I right in thinking that that is in essence what you're referring to there is the noise mitigation scheme in the unilateral undertaking which is now proposed?
There's a range of measures that have been discussed.
Yeah.
That we've talked about some of those.
Now the U at night proposes that those who experience noise levels above 55 dB LAQ 8 hour will qualify for the noise mitigation scheme. That's the way it works. There's also a daytime criteria, but at night that's the criterion that's used. Yeah?
Yes, that's correct. That's what's being proposed.
Okay. And if we can take out Mr. Williams's proof, please. And in that, turn to...
Sorry, you just have to bear with me while I
Sure.
get that. Okay.
I need to take us to page 49. And on page 49, we've got Mr. Williams's appraisal of the number of dwellings above the 55 dB LAQ 8-hour night threshold in 2030 with 12 MPPA. It's the 250 in the right-hand column, second from bottom.
So that's at 10 million passengers per. 12 million passengers per annum. Yes,
it's
I've
just
got that,
above
250.
Yeah, 250 people. So, as I understand the way the noise insulation scheme works, it in relation to the extension beyond 10 MPPA, it only commences when the 12 MPPA permission is implemented via a material operation. And it ends when 12 MPPA is reached, whatever point in time that may be.
I don't know the details, I'm afraid, of that
Okay.
specific proposed obligation.
The applicants within the 55 dB LAQ 8-hour contour get a maximum grant of £5,500 per house. So if it costs more than that amount to mitigate a house in terms of its windows, its ventilation for all the bedrooms, the scheme wouldn't cover the full costs, would it?
If it costs more, no, it wouldn't.
Yeah. And
I think Mr. Williams was cross-examined on this, I'm pretty sure, and confirmed that's a reasonable amount. And I think, in fact, goes beyond other airports and the requirements of national policy.
what evidence is there, what cost evidence is there that demonstrates that £5,500 is sufficient to pay for appropriate noise mitigation for any particular size of house, say a 5-bed or a 3-bed or indeed a 1-bed?
I'm not an expert on noise insulation, I'm afraid, so I couldn't comment on that. That'd have to be a question that's put, and I'm sure was put to Mr. Williams. I'm sorry.
The scheme has a maximum level of £200,000 a year that's on offer.
Yes, I'll take your word for that.
250 houses at £5,500 is 1.375 million. And if you divide that figure by 200,000, it would take 6.8 years, effectively almost 7 years, for all the houses to get mitigation.
But is
As a
your
matter
prem,
of,
is
as
your
a matter
prem,
of, as a matter of mathematics, do you accept that?
no,
You don't.
only because of the premise. Because I think my understanding, again, I'm not the noise expert, is that many of those properties have already benefited from the existing noise insulation scheme. So this doesn't apply to all properties.
How many of them?
It'd have to be a question for a noise expert. I'm sorry, I can't answer that. But I do know that I think from memory, and again, one that I'm sure was discussed with Mr. Williams, it's quite a large proportion of those will have already benefited from some form of insulation.
The £200,000 a year limit applies not just to those at night, but is also the fund for those in the various contours that apply during the day too. That's right, isn't it?
Yes, I think so, yes.
Yeah. And various different contribution levels apply to various different people. What's plain is by having a £200,000 limit, it is going to take some people quite a while to get their noise insulation, because not everybody can have it before the noise impacts arise.
Again, I think a large proportion have already received the insulation, so I think that already received grants. So I don't think I accept your premise. But again, the details of that is, I don't have those to hand at the moment, and I think that was a matter that should have been put, and probably was put, in fairness to Mr. Williams.
What is the evidence that demonstrates that a limit of 200,000 per year is appropriate?
Again, not a question. I think that's a question for Mr. Williams. What I do know is that the scheme being offered goes beyond the requirements set out in the the APF and indeed Aviation 2050. So I think on that basis, I would deem it to be appropriate.
We just looked at people above Seoul. Do you remember I was talking to you about what the noise policy position is for those above Lowell? If we look at the neighbouring table, neighbouring columns for the Lowell of 45 dB LAQA tower, there are 4,000 people in the Lowell contour, and of them 600 are newly placed in the Lowell contour compared to the 10 MPPA case. You see that?
Yes.
The noise scheme that's proposed by Bristol Airport Limited offers those people no mitigation whatsoever.
Yes, that's
Yeah.
my understanding.
Right.
Although, yes, that's my understanding.
Mr. Taylor, we are looking at the 106, well, tonight, and we'll be looking at it tonight and tomorrow.
We are.
In the round table. We're sort of getting very deep into some of the specifics of it.
I'm just trying to explore the extent to which Mr. Melling, who claims great things for the noise mitigation scheme, has actually applied the proper approach, particularly in respect of those above Lowell.
I take that point. I think we're just delving in a little bit too deep,
Okay.
and I've not seen the UU
If it's
yet.
not helpful, I'll move on.
So yeah, thank you.
Now, policy CS3, of course, seeks to prevent unacceptable environmental pollution or harm, doesn't it?
Could we just go back to the policy, sorry?
Yeah.
Yes, it states that it should be mitigated to an acceptable level.
Yes. And so part of considering mitigation to an acceptable level is considering whether those above Lowell who aren't given any mitigation at night have their noise levels mitigated to an acceptable level. That's part of the consideration, isn't it?
Yes, and in accordance with the NPSE, you also need to take into account the wider guiding principles of sustainable development. So I think the NPSE states at paragraph 2.24 that this does not mean that such adverse effects cannot occur. That's what the NPS
a mitigation scheme
states.
which does not include all reasonable mitigation to reduce noise for those above Lowell does not result in an acceptable level in accordance with policy, does it?
I disagree. I think there's a need for proportionality. I think the NPSE states that there's a need to take into account, that, as I said, the guiding principles of sustainable development.
And a development that increases the number of people experiencing noise above the soul level, or which increases the noise experienced by people already above soul, is a development which has an unacceptable environmental impact, isn't it?
I disagree. I don't think I don't consider that that is an unacceptable impact. You've got to look at the level of change that those receptors will experience, which the assessment in the ESA has demonstrated would not be significant. And you've also got to take into account the mitigation measures that are proposed in respect of those receptors.
And so
And that's what I've taken into account in
when
my
we come to look
balance.
at policy CS23 and ask ourselves whether the noise issue has been resolved, the only conclusion that one can reach in relation to this application is that it has not.
I disagree, and quite clearly it can't be the only conclusion, because, first of all, 3 points. Mr. Williams concluded that it's not unacceptable. I've concluded, on the basis of his evidence, that it's not unacceptable, and indeed, NSC's own officers, in recommending approval of the planning application, didn't consider that the impacts were unacceptable. So I disagree. I think that's not the only conclusion you can reach, quite clearly. That might be your conclusion, but it's not mine.
The mitigation scheme that officers considered all that time ago, which formed part of the basis of the officer recommendation, did not include a £200,000 annual limit on the availability of mitigation, did it?
I can't recall exactly what the limit was there. I think there was. I don't think that's changed. And also, I would say that since officers made their recommendation, the airport's put forward further mitigation. And this will be discussed tomorrow, I'm sure, but there's even further measures that the airport are now proposing.
Can we look at CD 411 again then, please, just to so I can put the point properly to you. Oh, I can't find it myself. And if we look in that, please, at page 231. On this page, it explains that an enhanced noise insulation scheme is proposed, and we see reference to the various contours. Grants will apply from commencement to development. Details of noise insulation grants will be submitted to and approved by NSC prior to the commencement of development. That's from Appendix 3 of the officer's report, and there is no reference to any limit at all on an annual basis in those heads of terms, is there?
Can you just bear with me on this, just before I answer? I just want to go back and look at the heads of terms at that time, if that's okay, and perhaps we could go there, because I just want to, before I give an answer to that, if that's
These are the heads of
acceptable.
terms. This is Appendix 3 of the officer's report, reporting the heads of terms to the committee. If you turn back to page 224, it says so.
Yeah, I just want to just check one point on this, if that's okay, before
Can we pick
I...
up on this tomorrow?
Sure. Okay. So, if that's right, and if what was on offer wasn't limited in a way, we don't know if officers would have recommended approval if they'd known that there would be a £200,000 limit, do we?
At the moment, I want to confirm what the limit is before I answer that, but
Okay, well,
I think it's quite clear. I don't think there's been a substantial change on this matter since the obligations were agreed with officers.
yeah.
So I'd like to check that before.
Fine.
I'm happy to come back on
let's
that
move
point
on to
tomorrow,
let's move on to air quality briefly. Now, Dr. Broomfield gave evidence that the air quality limits are not a threshold below which there's no adverse health impact, and Mr. Pearce agreed with that in cross-examination, didn't he?
Sorry, can you just
Yeah.
give me a second? So what was the question again?
Dr. Broomfield gave evidence that air quality objective limits are not a threshold below which there is no adverse health impact, and Mr. Pearce agreed with that proposition in cross-examination.
Yeah, below which there's no adverse effect. Yes.
Yes, he said they're not a threshold below which there's no adverse health effect. In other words, there are health effects below the thresholds.
Yes, yes.
And Dr. Broomfield's evidence was that the direction of travel was that health-based thresholds in terms of NO2, PM10 and PM2.5 would be likely to get more stringent over time.
I recall from his
Yeah.
proof of evidence that was his case.
And we now have the WHO guidelines published, I think, only a few days ago, and they publish what they call air quality guidelines, and they explain that the exceedance of the air quality guideline levels is associated with important risks to the public health, don't they?
I haven't looked at that document. I understand that that's a matter for further submission should parties wish to do so. What I do note is that that is not policy. That is not current policy.
It's a threshold set by the World Health Organization above which, if exceeded, gives rise to important risks to public health. That's what.
Not policy. It's not policy.
Right. It's a threshold, a scientific threshold that we can utilise to determine whether important risks to health, to public health, will arise in relation to the proposed development. That's right, isn't it?
I disagree. It's not policy. Secondly, I'm not an air quality expert. And thirdly, I haven't looked at the document.
Okay.
But it isn't policy, and we need to consider this against the policy. And in this instance, I consider it's the NPPF test that is most relevant.
All right. If you've not read the document, then I can't fairly put questions to you on that, and we'll deal with that in another way. In terms of the mitigation for air quality, there's a condition proposed that requires an air quality action plan to be produced. I think within 6 months of the grant of any planning permission, from memory. But there's not even a draft of that plan before this inquiry, is there?
No, there's not a draft of the plan.
No.
There is, I think, in the evidence of Mr. Pearce, he's set out some of the measures that that plan is likely to contain.
Okay. Now, in the context of air quality, I think CS 26 is the policy that we need to be thinking about. Now, my understanding is that your interpretation of policy CS 26 is that it simply requires an HIA to be produced, and then you've satisfied the first part of that policy. Is that right?
Yes, we've produced a health impact assessment which has considered, in accordance with that policy, adverse health impacts and beneficial health impacts in accordance with that policy.
Right. Well, let's see then whether or not there is actually a dispute between us. If we go to CS 26, please. I'm not sure whether I've got the reference. It's on page, internal page 102 of CD 5 point, oh, it's gone out of my head already. 5.6, yeah.
Sorry, I don't think it was that page 102?
102, yeah.
Okay, just, yes, got that.
So it aims to promote healthier lifestyles and reduce health inequality by, number one, requiring health impact assessments on all large-scale developments in the district that assess how the development will contribute to improving the health and well-being of the local population. The purpose of this element of policy is to ensure that all large-scale developments result in improvement to the health and well-being of the local population, isn't it?
No, the policy says to assess how the development will contribute to improving the health and well-being of the local population, and that's
right.
exactly what we've done. That's what's presented in the environmental statement and the environmental statement addendum, and that Mr. Piper referred to in his evidence.
I see. So if I had a large-scale development in Old Somerset right now, and I did my HIA and it identified that the scheme would give rise to material health, adverse health impacts and a reduction in well-being of the local population, I would comply with CS 26. That's what you're saying.
Would that health assessment have looked at the contribution towards improving the health?
Yes, it would have assessed and said, well, this scheme doesn't improve that.
Well, then in accordance, that's the policy. I didn't write the policy, that's the policy wording. So that's the policy wording is how I read the policy requirements.
That's how you read it, yeah.
How I read it,
Okay.
and well, inspectors will take their own view on this, but how I read it is requiring a health impact assessment on all large-scale developments that assess how the development will contribute to improving the health and well-being of the local population. Okay. We have undertaken that assessment, and we have identified how the proposal does contribute to improving the health and well-being of the local population.
Yes, I'll come on to that in a second, but just stick with this with me for the moment on this. Page 16 of the core strategy, please. We've got on page 16 the visions and objectives of the core strategy, and it says at 2.2 the starting point is the North Somerset vision, which set out in the SCS, which refers to sustainable, inclusive, safe, healthy, prosperous community thriving in a quality environment, and it says that to achieve that vision the SCS developed 6 shared priorities, one of which is improving health and well-being. And then we see that the role of the core strategy is to provide the spatial and land use expression of these shared priorities. If CS26 isn't the land use expression of a policy approach that requires the improvement of health and well-being, which policy does require development to result in improving health and well-being?
I don't think there's actually an express policy requirement in the plan that says
Right.
development should improve health and well-being.
Okay, so
I don't think, it's not, again, this is the council's plan. I don't think there's a policy in this plan that states that in express terms.
I see. So, in essence, what you're saying is that if one adopts your interpretation, then there is no land use expression of the priority for improving health and well-being in the core strategy.
Oh, there is. Policy CS26 contains a range of other measures which aren't relevant to this development, which meets that priority.
I see.
But that in terms specifically, and I think the supporting text of the policy, when you look at that, majors on things like the provision of healthcare facilities, the provision of open space. It's my reading of the policy is it's those elements that the policy envisages will deliver improvements in health. There's a requirement to undertake a health impact assessment. We've done that. There's no express policy requirement that development should improve the health and well-being of communities. In any case, Mr. Piper demonstrated in his evidence that the increasing the capacity of the airport will deliver some significant health benefits in terms of increased prosperity, jobs, and they've been identified in the health impact assessment in accordance with the provisions of policy CS26.
Let's just go back to CS26 then at 102, just look at the phraseology in it. It refers to large-scale development, and it refers to assessing how the development will contribute to improving the health and well-being of the local population. That is, population local to the large-scale development, isn't it?
Yes.
Yeah. It's not the population of North Somerset's administrative area as a whole.
It doesn't. The policy doesn't define what local population means.
Right. So we have to interpret it, don't we? And I'm putting to you that the appropriate way for determining the meaning of local population is that it is the population adjacent to the large-scale development. And you've already agreed that that's right.
No, I didn't agree that actually.
Right, okay.
I didn't agree that.
If
I said local community, local population isn't defined, and it's not defined in this policy either. That's what I said.
right, and so what Mr. Piper did was he interpreted local population as, in essence, the North Somerset administrative area. Although he looked at other wider areas too, didn't he? But his lowest level was the North Somerset administrative area.
I think I'd need to go back and double check, but I think that's how he defined local population, yeah.
If it's right that Mr. Piper didn't assess the local population to the large-scale development, in other words, the airport, and if it's right that you interpret CS26 in that way, then his health assessment did not examine whether the development would contribute to the health and well-being of the local population as required by CS26.
I fundamentally disagree with your premise. The health impact assessment has considered the effects on a defined population. The health impact assessment was undertaken in accordance with the approach agreed with officers. So I think that's the position there, and that I think Mr. Piper was quite clear on that in his cross-examination.
Okay, let's one, I think, last point on this aspect of policy. Given the time, I want to take us to the APF again, please. And we need to go to page 65 of CD 6.1. And at paragraph 351, the government explains that NOx emissions from aviation-related operations reduce rapidly beyond the immediate area around the runway. Road traffic remains the main problem with NOx. Airports are large generators of surface transport journeys and as such share a responsibility to minimise the air quality impact of these operations. The government expects them to take this responsibility seriously and to work with the government, its agencies and local authorities to improve air quality. So the APF objective is an improvement in air quality, isn't it?
The general principle is that the government, its agencies and local authorities will work to improve air quality.
Yeah.
That's what it says there.
And
I think the government is taking those measures.
if it were the case that the proposed development increased the risk of important health effects to the public compared to the position if planning permission were refused, the development would not achieve that policy objective of improving air quality, would it?
I disagree because there's no requirement for development to improve air quality. I don't see whether anywhere in the APF, anywhere in the MPPF, or in the development plan, there's an express requirement in policy terms to improve, for development to improve air quality. I don't think there is. I think
Let's go to the MPPF then, if that's your answer. Paragraph 174 on page 50.
Sorry, what was the page number?
It's page 50 of the MPPF, paragraph 174. Planning decisions should contribute to and enhance the natural and local environment by. So the objective is to contribute to and enhance the local environment by, and then we look at E, the second sentence, development should, wherever possible, help to improve local environmental conditions such as air and water quality. It says that the objective of this policy is to deliver improvement wherever possible to air quality.
Wherever possible.
Yes. And in terms of what's possible, we don't have any appraisal by Bristol Airport Limited of what's possible. There's not even a plan available yet of what measures can be taken, never mind an assessment of how effective they would be.
But that's not the key policy test, if I can take you there. Just bear with me a moment. It's always difficult when the paragraph numbers have changed. So if I could take you to paragraph 186 of the MPPF, page 53.
Yes.
My opinion is that this is the key test. So planning policies and decisions should sustain and contribute towards compliance with national objectives for pollutants. The evidence of Mr. Pierce has demonstrated that the development will not result in any air quality objectives not being met. And therefore, I think the development is in accordance with the MPPF. And indeed, again, I come back to the point, I think this is what officers reach the very same conclusion when considering the planning application.
If it were the case that the airport development proposed here gave rise to adverse impacts above a level which represents an important risk to health, that would mean that unacceptable environmental pollution or harm is not being prevented, and the development would be contrary to CS3. On that premise,
If the development sorry to cut across you. If the development resulted in emissions which meant the government's air quality objectives could not be met, then that clearly would be an adverse impact. But that's not the case here.
Well, we're yet to put in our submissions on the WHO guidelines.
But that's not policy. I'm not talking about the WHO guidelines. I'm talking about the government's air quality
Yes.
objectives.
I understand what you're talking about entirely. I'm talking about health-based standards. Now, CS23 as well, if no mitigation is proposed, which results in improvement in air quality, or which protects the public from a rise in important risks to public health, if the mitigation was unable to achieve those objectives, then the environmental issues in relation to air quality would not be resolved for the purposes of CS23, and there would be a breach of that policy too, wouldn't there?
If, however, the environmental statement and the environmental statement addendum have demonstrated that the air quality impacts associated with an additional 2 million passengers per annum will not be significant. Again, concentrations of all pollutants will remain within the limits, within the legal limits, which I contend is the key policy test here. Secondly, measures are being proposed to seek that will generate improvements in air quality, measures such as investment in public transport and the delivery of the Air Quality Action Plan.
Yes.
The A38 works will also deliver benefits in terms of air quality.
What we don't have, though, Mr. Melling, is any appraisal which looks at the quantification of the impact of those measures, do we?
I think Mr. Pearce has considered in the ESA the impacts of the A38 works because they form part of the scheme. He's considered those. But the starting point is there aren't significant effects. So I don't know if I follow your line of argument there.
All right. Surface access, I don't think there's any different interpretation of policy between you and the council as far as I'm aware. Are you aware of any?
Which policy?
We've looked at, I think, PS, there's a difference in terms of whether the policies are whether there's accord with policy, but in terms of the tests in the MPPF and the core strategy, I don't think there's a disagreement about
No,
the
I don't think there is.
interpretation.
No, I think in terms of what are the relevant policies, yes, I think,
Okay.
I think Mr. Gertler and I agree on that, yes.
All right. I've got two short points on Greenbelt, and I think we can draw stumps for the day, if that's acceptable. In terms of the Greenbelt, we've got paragraph 148 of the MPPF.
If you just bear with me while I get there.
Yes. I was going to take you there, don't worry. So it's the second sentence I was interested in. The very special circumstances will not exist unless the potential harm to the Greenbelt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. The point I was putting is it's not a straight balance. The harm side of the balance has to be clearly outweighed by other considerations.
Yes, that's what it says there, yes.
Yeah, okay. All right. I think
And we have, I know we had a long discussion. In my view is that we have demonstrated those very special circumstances.
yes, as I said, I'm not going to try and change your view on balance and things like that. All right, I think that's probably time to draw up sticks. I've got a bit on benefits to do tomorrow, but I'm not going to be too much beyond my half an hour or so. Maybe it might be 40 minutes.
Okay, all right, well, thank you everyone for today. We'll reconvene at... Oh,
I don't know if there's probably not anybody from Highways England listening, but the representative from Highways England, National Highways, is going to come tomorrow and requested a slot at 12 o'clock. I mean, I don't know whether that officer has much experience of planning inquiries, because it doesn't quite work on that basis. But we have gone back through the programme officer to try and advise as best we can when we might be able to hear that officer. And we had indicated about 12 o'clock, although I think that's probably a bit optimistic. So if that officer wants to follow the proceedings tomorrow, we may be able to give a bit more of an accurate update when we get to the mid-morning break, something like that, but it's probably going to be in the afternoon before we get to that part of the condition session. Thanks.
have a good evening, everyone.
Thank you.